Judge Caldwell exhausted all tolerance, and the federal officers acted without delay. What you're witnessing is extraordinary. A government tribunal magistrate driven past his threshold, commanding swift extraction of an accused from his chamber. 0 alerts, 0 additional opportunities. Officers advancing before the statements completely escaped his lips. And then the revelation nobody anticipated. Custody revoked instantaneously. This wasn't performance. This wasn't posturing. This was a government magistrate proclaiming before recording devices and a filled chamber that sufficient is sufficient. When a presiding magistrate regards armed government personnel and declares, "Extract him instantly," you recognize something devastating just transpired. Here's precisely what occurred and why everyone discusses it. So what activated this remarkable instance in his chamber, on what should have been a standard preliminary proceeding? Judge Caldwell observed something that demolished his renowned tolerance, a tolerance that has endured through multiple decades on the government tribunal. This isn't merely another chamber explosion documented on recording. This is a government magistrate executing a deliberate judgment to activate his complete power instantaneously with the entire judicial community observing. The accused, who had previously challenged limitations in earlier engagements, violated a boundary that Judge Caldwell established clearly would never be violated again. What transpired in those volatile 90 seconds now receives examination by judicial specialists throughout the nation. Previous prosecutors characterize it as a demonstration in tribunal power. Protection counselors characterize it as frightening, and I possess the chamber reports, the judicial submissions, and specialist evaluation right here. But here's the element. What activated the extraction constitutes only component of the narrative. The custody rejection that succeeded, that's where this becomes genuinely extraordinary. Because when a government magistrate withdraws your liberty mid-proceeding with officers previously positioned beside you, your complete judicial approach just disintegrated. Let me demonstrate precisely what they're attempting to manipulate. Here's what genuinely transpired inside that chamber the instance everyone accessed to observe. The proceeding initiated at 10:17 a.m. According to chamber witnesses, the accused entered with what observers characterized as apparent disdain, declining to recognize the magistrate, communicating audibly to his judicial association, and at one moment seeming to express amusement during systematic declarations. This is it. This is the instance that transformed everything. Judge Caldwell, following addressing initial subjects, directed to the matter of the accused's adherence with preliminary conditions. That's when the accused interjected, directly severing the magistrate mid-statement. According to journalists present, the accused announced, "This tribunal possesses 0 power over me. I don't acknowledge this action." Judge Caldwell paused. The chamber became quiet. He provided the accused one chance, merely one, he stated composedly. "You will behave yourself with deference for this tribunal, or there will be swift repercussions." The accused's reply, he allegedly directed toward the assembly and executed a dismissive motion toward the platform. That was the catalyst. Judge Caldwell's tone, according to various witnesses, transformed instantly, not elevated, but icier. He announced, "Officers, extract this person from my chamber instantly. We are concluded." 2 U.S. officers stationed near the lateral entrance advanced without delay. The accused barely possessed duration to respond before he was physically guided toward the detention zone. But here's the revelation. Judge Caldwell wasn't concluded. As the officers advanced, the magistrate proceeded, "Let the documentation indicate that the accused has exhibited intentional disdain for this tribunal's power. Based on this behavior combined with recorded breaches of preliminary liberation conditions, the tribunal is withdrawing custody effective instantly, withdrawing custody instantaneously with the accused being physically extracted." Judicial observers who assessed the documentation highlighted that this wasn't spontaneous, it was deliberate. Judge Caldwell referenced particular breaches, absent verifications with preliminary operations, claimed interaction with witnesses despite a prohibition directive, and digital platform transmissions that seemed to endanger tribunal personnel. The accused had allegedly absent 3 arranged verifications over the earlier period. Tribunal materials demonstrate that preliminary operations had submitted 2 traditional notifications of resistance, both of which had been addressed in previous proceedings with cautions. Those cautions expired the instant the accused interjected the magistrate. The custody withdrawal directive submitted within the duration contained terminology infrequently observed in government actions. Judge Caldwell composed, "The accused has exhibited a foundational reluctance to adhere with the conditions of liberation and has demonstrated disdain for the tribunal procedure personally. Sustained freedom presents an unacceptable danger to the legitimacy of these actions, and it intensifies. According to contacts acquainted with the matter, examiners had been constructing a matter for custody withdrawal for periods. The accused's digital platform engagement, despite being commanded to restrict open declarations about the matter, encompassed transmissions that prosecutors contended represented witness coercion. One transmission, according to tribunal submissions, referenced persons considered to be assisting witnesses by their characters with terminology the administration portrayed as barely concealed dangers. Judge Caldwell, in his composed directive, addressed this straightforwardly. The accused's open interactions exhibit not simply inadequate assessment, but a deliberate attempt to weaken the execution of fairness. Previous government prosecutor Marcus Webb informed judicial witnesses that this degree of recording indicates the magistrate had been anticipating and chance. This wasn't responsive. The withdrawal directive was prepared. The accused's chamber conduct simply furnished the concluding validation. The accused now receives detention without custody, awaiting prosecution, a condition that in government tribunal is remarkably challenging to overturn. His judicial association possesses 24 hours to submit a crisis petition. Hit that subscription control immediately now, because what transpires subsequently in this matter might transform how government magistrates address resistant accused countrywide. I'm transmitting each advancement as it materializes, and you'll desire to be here for all of it. Now, you've observed what transpired, but here's how we arrived here, and it renders Judge Caldwell's judgment even more validated. This opposition didn't surface from nothing. Pressures had been intensifying for periods, driven by the accused's sequence of challenging limitations, examining tribunal tolerance, and regarding tribunal actions as a stage instead of a judicial assembly. Everything transformed during a proceeding. 3 periods earlier, when the accused initially opposed Judge Caldwell's power openly, according to tribunal documentation from that previous proceeding, the accused interrogated whether the magistrate possessed authority to establish any preliminary conditions whatsoever, a judicially groundless assertion that the magistrate rejected but recorded for the documentation. At that duration, Judge Caldwell announced, "This tribunal's tolerance should not be interpreted for vulnerability. I am furnishing flexibility. That flexibility can be retracted." The accused evidently understood that caution as in vacant danger. Over the succeeding periods, preliminary operations recorded a sequence of systematic resistance. The accused would verify late, occasionally by durations, occasionally by intervals. He would furnish incomplete details about his position. He would deliver forms with absent signatures. Each breach personally might seem insignificant, but government magistrates acknowledge sequences. On a proceeding 6 periods before the volatile extraction, Judge Caldwell addressed these breaches straightforwardly. He announced, according to the documentation, "I am positioning you on traditional notification, 1 additional recorded breach, and I will consider a petition for withdrawal." The accused's counsel guaranteed the tribunal that adherence would advance. It didn't. 2 periods subsequently, preliminary operations identified the digital platform transmissions. The transmissions, while not explicitly endangering, referenced the matter in approaches that bordered and potentially violated the defensive directive. When prosecutors submitted a traditional petition for custody withdrawal, they encompassed screenshots, chronological markers, and specialist evaluation contending that the transmissions were created to coerce witnesses. The proceeding where the officers advanced was arranged particularly to address that petition. Judge Caldwell had previously assessed the proof. He had previously consulted with tribunal protection. The officers were stationed particularly because the magistrate foresaw the likelihood of an opposition, what the accused didn't comprehend. What his judicial association evidently neglected to transmit is that he was entering into a chamber where each possibility had been arranged. When he interjected the magistrate, he wasn't examining an unready jurist. He was activating a reply that had been strategized for precisely this situation. Impact that engagement control if you're monitoring this, because comprehending how we arrived here is essential for comprehending what transpires subsequently. Execute an engagement so additional individuals observe this analysis. I assess each individual statement, and I desire to receive your perspective. The revelation instance arrived when the officers physically stationed themselves on both aspects of the accused, and he still didn't cease. According to witnesses, including as government personnel close proximity, the accused persisted communicating. He allegedly announced something to the impact of, "You cannot silence me. Everyone observing recognizes what this represents." Judge Caldwell's reply was swift and crushing. He announced, "For the documentation, let the record indicate that the accused is persisting to interrupt these actions, including as he is being legitimately extracted. This behavior will be integrated into penalty considerations should there be a determination." The chamber experienced absolutely quiet. Journalists present characterized the climate as charged, a combination of astonishment and, among certain witnesses, apparent comfort. One tribunal illustration artist, who has transmitted government actions for 23 periods, informed information afterward. "I've never observed anything comparable." The magistrate's tone never elevated, but the power was complete. As the accused was guided through the lateral entrance, he allegedly endeavored to direct back toward the assembly. Officers physically redirected him. The entrance sealed. Judge Caldwell, without halting, addressed the remaining counselors. "We will execute a 15-minute pause. When we continue, we will advance with the administration's alternative awaiting petitions." And merely like that, it was concluded. Except it wasn't because what transpired in those 90 seconds now reverberates through each government chamber in America. This was a communication, and each accused observing received it audibly and unmistakably. Remain with me, because the ramifications of this are substantial. But initially, execute a statement immediately now. Did you observe this approaching? Do you believe Judge Caldwell was correct to function this conclusively? I assess each individual statement, and I desire your perspective. This isn't the initial duration a government magistrate has commanded officers to extract a resistant accused, but the circumstances render this extraordinary. Reflect back to the Chicago 7 prosecution in 1969. Judge Julius Hoffman, confronting persistent interruption from accused Bobby Seale, commanded him restrained and silenced in the chamber. That judgment was subsequently condemned as disproportionate, and Seale's determination was ultimately reversed. The essential distinction now, Judge Caldwell didn't endeavor to persist with a disruptive accused present. He extracted him instantly and withdrew custody, removing the likelihood of additional chamber oppositions completely. Then there was the 1988 matter of taxation objector Irwin Schiff, who continuously interjected government magistrates with assertions that revenue taxation was illegitimate. He was extracted from various chambers and ultimately prohibited from submitting professional judicial materials. But including Schiff wasn't detained without custody for chamber behavior exclusively. What renders Judge Caldwell's judgment distinct, what judicial researchers now evaluate intensely, is the blend of swift extraction and custody withdrawal in a solitary instance. Professor Sarah Chen, who instructs criminal methodology at Georgetown Law, clarified, "Customarily, these are distinct actions. You extract someone for disdain, then arrange a subsequent proceeding on custody." Judge Caldwell compressed both into one determination, and he possessed the recording to validate it. That recording is essential because Judge Caldwell's directive didn't depend exclusively on the chamber explosion. It referenced periods of gathered breaches, constructing a documentation that validated swift detention. This is what experienced government magistrates execute. They don't respond spontaneously. They construct matters including against accused in their personal chambers. The sequence is unmistakable. When accused examine tribunal power continuously, the repercussions intensify. Now, nevertheless, those repercussions materialized all simultaneously before recording devices, before the judicial community. In an instance that will be examined for multiple decades, Judge Caldwell didn't merely extract a disruptive accused. He formed a framework for tribunal reply that tribunals countrywide already discuss. Judicial specialists characterize this as a critical instance for tribunal power in government actions. Marcus Webb, a previous government prosecutor with 18 periods of involvement in prominent matters, informed judicial information that Judge Caldwell's measures were standard but enhanced. He clarified, "Each initial period prosecutor acquires that you construct a documentation before you execute a substantial action." Judge Caldwell unmistakably possessed periods of recording prepared. The chamber opposition was merely the concluding component, but implementing both the extraction and the custody withdrawal instantaneously that demands supreme faith in your judicial standing. Webb appended that the accused's judicial association now confronts an almost unachievable petition opposition. You'd have to contend that the magistrate functioned without adequate justification, but the documentation demonstrates continuous cautions, recorded breaches, and behavior that any reasonable jurist would discover unacceptable. Meanwhile, constitutional legislation professor David Armitage from Harvard Law School highlighted the wider ramifications. This transmits a communication that government tribunals are not stages for governmental performance. Armitage announced, "Judge Caldwell established unmistakable that the chamber is his territory, and accused who disregard that execute so at their danger. The constitutional matters are minimal. Accused possess zero entitlement to interrupt actions." A criminal protection counsel communicating on foundation presented a more preventative outlook. Protection lawyers observe this attentively. The apprehension is that magistrates might experience authorized to function more intensely on reduced proof. Judge Caldwell possessed a substantial documentation. Not each magistrate will, but including protection-oriented observers, recognized that the accused's behavior was disproportionate. Previous community protector Natalie Reyes, presently a judicial analyst, acknowledged, "Observe, there's passionate representation and there's personal annihilation. This accused selected personal annihilation. Zero lawyer could have rescued him from himself in that instance." Reyes recognized that the accused's counsel seemed apparently troubled during the extraction. You could observe it instantaneously. The lawyer recognized precisely what was occurring and couldn't prevent it. This is a catastrophe situation for any protection assembly. What renders this matter especially meaningful, according to various observers, is the transparency of the documentation. Judge Caldwell's composed directive submitted within a duration of the chamber opposition extends 11 sections. It records each absent verification, each borderline digital platform transmission, each caution released in earlier proceedings. Previous petition judge Patricia Hammond, presently retired, clarified that directive wasn't composed in a duration. It was prepared. He was anticipating this instance, not desiring for it, but arranged for it. That's the distinction between a responsive magistrate and a calculated one. If this evaluation is beneficial to you, impact that engagement control immediately now. It authentically assists additional individuals observe this transmission. The system rewards participation, and your engagement assists this contact individuals who merit to recognize what transpired. So, what does this genuinely signify progressing forward? Initially, the accused confronts swift detention until prosecution, which might be periods distant. Government detention awaiting prosecution is famously challenging to overturn. The accused's counselors would require to exhibit either that Judge Caldwell misused his judgment, improbable given the recorded documentation, or that transformed circumstances warrant reassessment. But here's the challenge. The accused's behavior in the chamber now constitutes component of the continuous documentation. Any petition tribunal assessing the custody withdrawal will observe precisely what transpired. They'll assess the record, they'll observe the recording of earlier breaches. On one aspect, the protection will contend that custody withdrawal for chamber behavior is disproportionate. On the alternative, prosecutors will indicate a sequence of conduct exhibiting that the accused cannot be relied upon to adhere with tribunal commands. The subsequent ramification, this influences how each government accused behaves themselves progressing forward. Protection counselors countrywide already transmit revised instruction to participants. The communication is unmistakable. Government magistrates possess power. They will implement it, and chamber resistance will not be accepted.